Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an amazing and productive Blackout Friday. Hey, y'all, so as y'all seen in the title, this is an update in regards to the James Wright versus Chrisean Malone case. If you are just coming out of a coma or from up under a rock and don't know what's going on, I'm going to give you a 20-second summary. James Wright filed a lawsuit against Chrisean Malone earlier last year for injuries that he sustained at Braxton's Love and War tour. All right. So the civil suit was in regards to assault and battery. Now, y'all have been with me long enough to know that when you file a lawsuit as a plaintiff or a petitioner, you bear the burden of proof, meaning you have to prove your damages. We have gone over James's declaration where he submitted some documents, some documentation that included a medical bill, actually a dental bill, a therapist bill, a few of his potential pay stubs from events that he had to cancel, and so on and so forth. But it wasn't enough to neg- it wasn't enough to prove that he was rightfully owed 140K. Now, he was asking for 15,000 in attorney fees, I believe 2,000 and something dollars for process server fees, I think 50,000 for pain and suffering, and then as far as the bills that he submitted, it was around 77,000, okay? Now, with that being said, and I'm saying this as a plaintiff paralegal, okay, that does personal injury. If I was working on James' case, I would tell him up front that I need the following documentation. James submitted a therapist bill, but no therapy records. So that way I or the attorney can see that it was medically necessary for you to have therapy due to that incident. He also submitted dental records, just a dental bill, not dental records, but a dental bill. And it wasn't even a bill, it was an estimate. Now, I don't know if he had the work done or not, but it wasn't a true bill to say, okay, it was medically like showing that you got, first of all of these veneers in your mouth. And we didn't have the records to show that it was medically necessary for you to get your whole mouth replaced. Okay. Then he also submitted invoices or potential invoices for events that he had to cancel in regards to what happened that caused him not to be able to do his job. So, as a paralegal, what we do is we will sit there and we will review and say, okay, what does your wages look like on a consistent basis? Do you get paid monthly? Do you get paid seasonally? And we have to go back about a good 5 years to see a pattern before we can say, okay, yeah, you definitely around this time, you make this amount of money, so on and so forth. Okay. And then we might get experts in the long run. But as far as what James submitted, it wasn't enough to prove his damages. Thus, the reason the judge ordered only $37,000 as a default judgment. Okay. That's part one. Part two is, how can he get a default judgment? That's another question that a lot of people ask. I'm going to explain to you guys. And I explain this time and time again. Number one, when you are served a lawsuit, you have so many days to answer that lawsuit. I think in California it's 30 days. Chrisean did not respond to that lawsuit within 30 days. On that last expiration day, or that day that her time to respond expired, James was supposed to file his default judgment within a certain amount of time after the expiration of Chrisean responding. He didn't do that. Then a couple of months passed. James went ahead and he filed his default judgment, or a request for a default judgment. Shortly after that, it was rejected. But then Chrisean filed her answer on October the 3rd. Then James refiled his request for a default judgment shortly after. Now, because Chrisean answered, the court gave her an opportunity to go on with the litigation process. So normally you go through discovery, as the attorney did state in her case management statement. And at that time, Chrisean Rock's attorney, or Chrisean Malone's attorney, would have requested medical records and bills and employment records from James to see, okay, what can we offer you? Two things could have happened. Either he submitted records to them and it wasn't enough to prove up his damages, or two, he didn't have anything to prove. He just had what we seen was filed. Okay, so it's not really much to work with. So that's out the way. Now, coming to how is he going to get paid since he got the order? Some people was like, well, Chrisean, she should just pay $5 a month. And then some people was saying James needs to just garnish her bank account, so on and so forth. There's a process that you have to do all of this in. Okay. I don't think that Chrisean would have qualified to just be on the payment plan, but it is up to the creditor as to how you can pay back that money. Think about some of the credit card that you guys have ran up and it's now in collections and they actually filed the lawsuit against you. Now, as the debtor, you would call them and try to work out some payment plan. I don't think Chrisean is going to call James, and I don't even think James is going to want to sit here and take a payment plan. Which leads me into the topic for today. As y'all seen, James has issued or requested an issuance for execution for the judgment that he was granted back on February 10th. Now, I was like, I know a little bit about California law when it comes to the judgment portion, and I could have sworn that you have 30 days to pay a judgment after the order has been signed. So if the order was signed on February 10th, that makes March 10th 30 days. And then you can be able to file an application for a writ of execution. But that was not the case here. So I don't know if there was any sidebars with the attorneys and with the courts to say, hey, you know, I'm trying to get this money as soon as possible, da 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 da. Thus, the reason why he was able to file this. But anywho's, he filed a writ of execution on the 19th of February. And so the process of that is you file this application. This is the EG 130. You fill it out. So you have the who the wit is going to, either the sheriff or a process server, the name of the creditor, the name of the debtor, who is Chrisean, and the amount that is being collected. Now, the good thing about this is that there was no pre or post judgment percentage on here. So thank God for that, because she would be like Blueface and that stuff is accruing on a daily basis. Now, the writ of execution, this actually lasts, it is active for 180 days. After that 6-month time period has expired and you have not collected your funds, then you would have to go and renew this. Okay. So, let's say she didn't pay and they have to renew it, it's going to be the same, probably 37,146 plus another $40, because that's the price of the issuance of a writ. But as of right now, all Chrisean has to pay is $37,146. Okay. Now, what happens is this application, the wit, and instructions will more than likely go to the sheriff. And people was like, okay, well, what can the sheriff do? The sheriff can do a lot, and people don't realize that. So once the sheriff gets a hold of this, right, it has the details of how much is owed, the debtor's information, obviously, and I redacted her address, right? Um, Once it gets into the sheriff's hands, the sheriff has to do his own research. He has to identify any assets that belongs to the debtor at this time that can be gathered or collected in order to satisfy this 37,000. Okay. So technically there's only two ways. Either you got money in your bank account or we're going to garnish your wages. And if she had a business, then they could just easily go up in the business and be like, "Hey, I'm collecting the cash, I'm collecting the checks." So anything that they made for that day, and this she don't have a business. And Blue, not Blue Soul Food, the seafood place is not in jeopardy. Krishan is not on anything, so they cannot collect from the business. Okay, so that's out. The only way that the sheriff can collect is by either accessing her bank account or garnishing her wages, whatever income that she has. And if let's say that she did have a stable job, only 25% can be deducted from, that the her wages, however she gets paid. Let's say she gets paid on a monthly basis, then 25% will come out of that. If she gets paid on a weekly basis, then 25% will come out of that, and 25 will continue to come out 25% will continue to come out until this judgment is satisfied. Okay, so the sheriff is going to do his due diligence. He's going to find out what assets you have. Then he's going to come to you and say, "I need to collect." That's it. That's all. It's out of our hands. There's nothing we can do. Now, if he comes to her and say, "Hey, I need to collect this $37,146," she say, "Okay, let me write you a check," then it will be done with. It's as plain as simple as that. But there's no other way around this. She can't appeal anything. Um, it is what it is. It's a judgment. The judgment has to be paid. Point blank, period. As simple as that. But y'all let me know what y'all think about this in the comments below. Don't forget to like, share, and subscribe. And also, if you are going to be in the comments, please be respectful because I do not mind blocking or removing any comments. I don't do with the disrespect, so keep it cute in the comments. But until then, you all have a blessed and happy Friday. Bye.